and then we'll move on from there. Let's pray. Father, thank you for allowing us to be here today. Thank you for the gracious benefit of a beautiful day and keeping the rain off. And despite the setbacks we've had, we want to thank you for the many blessings we've had that we could be here today. We do pray for Jen and for Daniel today, who are both sick and unable to be here. And I ask that you would give them help and give them comfort and healing in their bodies today. I pray for Dr. Vieira, for Tom Carroll, and for Ken as they would speak, and just ask you to give us guidance in the course of this event. We pray it may be done for your glory and the upbuilding of the kingdom and the restoration of the republic. We ask in Christ's name, amen. All right, ladies and gentlemen, Dr. Edwin Vieira is a constitutional attorney. He's spoken before the Supreme Court, presented before them. He's a rich history of writing on the subject of the militia, and you can find that on many sites, one of which is News with Views, which is where I found them. So this is Dr. Edwin Vieira. Dr. Vieira, I'm going to give you the floor, and I'm going to do my best to hold this up to the mic where everybody can hear what you have to say. So we'll give that a test now. Go ahead.
Okay, Daniel, can you hear me?
Yes, we can.
All right, good. Shall we start?
Yes, please proceed.
All right. Members of the listening audience, as they used to say in old-time radio, this is a rather dense subject. And one thing you need to do, at least in listening to me today, is to try to disabuse yourself of preconceived notions, which you may have developed through the Heller case, the McDonald case, the Bruin case, because we're going to go slightly outside and around those cases as the real source of information here. For the simple reason the Supreme Court opinions are opinions. They're not necessarily correct interpretations or applications of the Constitution. And we know that because the Supreme Court overrules itself on constitutional issues all the time. So if they decide something in case A, it overrules itself in case B. The one thing we know is that A and B cannot both be right. B might be right, but then again, A might be right, or they both might be wrong. And some opinion C would be the correct one. And you can see this in a case called Payne versus Tennessee, if you're interested in looking these things up. Volume 500 of the Supreme Court reports. There's a footnote in that case which lists in very small type decisions in which the Supreme Court has reversed itself in the past. And I know for a fact that those aren't all of them, because in many cases they don't say that they're reversing an earlier opinion. They come up with some other language to indicate to lawyers that lawyers should not rely on that earlier opinion, but they don't actually reverse it. So that's one of the problems in dealing with court opinions. We have to go back and validate the opinion by referring to the actual Constitution. And to do that, we have to follow certain interpretive principles which have been recognized in Supreme Court opinions. And the most important one is that we are bound to interpret the Constitution in the light of the law as it existed at the time it was adopted. Either the Constitution itself, the Bill of Rights, subsequent amendments, what have you. That's a case, a Maddox case from 1895. So we're talking about a principle that's recognized for a long time. We can go back to 1898. Construing the Constitution regard is to be had not only to all parts of the Constitution or of any former act of the same lawmaking power, such as the Articles of Confederation, but to the condition and the history of the law as previously existing. So it's talking about historical understanding of legal principles. Now, another important principle that we have to follow is that we cannot presume that any clause of the Constitution is intended to be without effect. Effect must be given to each word of the Constitution, and we cannot interpret any sentence, clause, paragraph as if the words that are there were not actually to be found there. Each word has to be given its appropriate force and meaning, because every word appears to have been weighed by the founders or the framers with deliberation and to have been understood by them in a particular sense. So we cannot assume without some clear reason to the contrary, and there hardly is ever such a reason, that any part of any amendment can be considered to be superfluous. Also, we must consider all provisions of the Constitution in light of all other provisions. This is an integrated document. One part of the Constitution is not separate and necessarily independent of all others in terms of interpretation. All principles of the Constitution are of equal dignity, and none of them can be enforced so as to nullify or impair any other. You can't simply dissever some part of the Constitution from some other part. You have to come up with an interpretation that integrates them all. They all must be interrelated. And if some construction, interpretation of the Constitution neutralizes another provision of the Constitution, then that interpretation must be erroneous. That's a fundamental proposition. We'll see how that plays out. And then, of course, we come to the concept of exceptions in the Constitution. And you find this often in judicial opinions. They will say, well, there's some implied exception to the Second Amendment, the Fourth Amendment, the Fifth Amendment. Well, that's a false principle, too, because where no exception is made in actual terms, if it isn't actually written there, then it should not be made by implication, or what they call, what is called construction, which is a form of implication. Another principle that's very important, we will get to this later on and use it, is that affirmative words in the Constitution must be construed negatively as to all other possibilities. So we're going to see the Constitution requires that Congress shall provide for arming the militia. By hypothesis, that means that Congress does not have a power to disarm the militia, because the affirmative word arming cannot be taken to include the negative word disarming, because they're contradictory of one another. And if there is general language in the Constitution, that general language is meant to be used as a generality. So if we look at the Second Amendment, which says the right of the people to keep and bear arms shall not be infringed, that's pretty general language. Why would we need to worry about specifics? That principle of infringement was to be applied in all circumstances. So why should we worry that the framers did not give us a list of possible infringements when every possible infringement was obviously to be precluded? And then also, the Second Amendment, as we see, relates to the original Constitution and even before that, to earlier documents. We must recognize that the same word in different provisions of the Constitution should be taken to have the same meaning. So when the Constitution talks about Congress providing for arming the militia, and the Second Amendment talks about the right of the people to keep and bear arms, actually in relationship to a militia primarily, then we would say, well, those are the same terms. The verb and the noun should be interpreted in similar fashion. And then we come to the concept of the living Constitution. Most, what shall I say, quote-unquote, progressive lawyers say that we can change the meaning of the Constitution with respect to different periods of history because social and economic and political circumstances change. Well, that's totally invalid. And that's why we have Article 5, the amendment provision, to deal with that type of situation. But the real meaning of that term, the valid meaning of that term, is that principles in the Constitution will apply to certain subject matter, even though that subject matter was unfamiliar to the founders. So if we look at the Commerce Clause, Congress has the power to regulate commerce among the several states. Well, commerce in the days of the framers was limited to canals, ships, horse-drawn vehicles. They didn't even have railroads at that period of time. Now, subsequently, we have instruments of commerce, railroads, automobiles, trucks, airplanes, so forth and so on. But we can see that those are all elements of commerce. They fit that definition. We're not bending the Constitution to include them. The Constitution is simply using that term to apply to subject matter that wasn't foreseen, or perhaps couldn't even have been foreseen at the time of the framers, but does fit into the meaning of that constitutional power. All right, so where does that take us after we know something about constitutional interpretation? We have to understand what is the relationship of the Bill of Rights to the original Constitution. Well, most people don't know this, but the original Bill of Rights had a preamble. And the preamble states that the convention of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, proposed that certain amendments be submitted to the states, and some of them were. Some of them were not, but some of them were. Second Amendment was one of them. In a sense, these, if you look at most of them, they're not true amendments because they don't nullify or change powers or limitations on powers that were already existing in the Constitution. You take the Second Amendment, for example, Second Amendment, or let's take the First Amendment, because that's perhaps the most obvious one. Congress shall make no law respecting the establishment of religion. Well, there's no power in the original Constitution to establish a religion. It just isn't there. If you look at the Second Amendment, the right of the people to keep and bear arms shall not be infringed. Well, there's no power in the original Constitution specifically to infringe that right, what we would call modern-day gun control. It doesn't exist. So, what were the Bill of Rights intended to do to prevent misconstruction or abuse? Misconstruction being misinterpretation. Someone simply doesn't understand what the provision of the Constitution means. He's making this error inadvertently, accidentally, unintentionally, without a perverse purpose. On the other hand, abuse is a perverse purpose. The person attempts to misinterpret, misconstrue that provision, knowing that he's doing that. He's trying specifically to limit some power of the government or to limit some limitation on the power, knowing that what he's doing is perverse, improper, illegal, if you will. So, what we need to do then, in all of these cases of dealing with any of the Bill of Rights, or actually any of the amendments to the Constitution, is to look back and see to what subject matter in the original Constitution does this amendment possibly apply. And it's very clear with respect to the Second Amendment, because the Constitution is full, the original Constitution is full of provisions that relate to the concept of arms and the militia. You have Article 1, Section 8, Clauses 15 and 16. We've talked about those. Article 2, Section 2, Clause 1, that's the power of the President. Article 1, Section 10, Clause 3 actually relates to troops, which is taken in contrast to the militia. And then there's Article 1, Section 8, Clauses 12 through 14, which deal with the Army and Navy, which are distinct from the militia. So if we simply look at the Constitution in light of the Second Amendment's reference to a well-regulated militia, we see Article 1, Section 8, Clause 15, Congress shall have the power to provide for calling forth the militia, execute the laws of the Union, express insurrection, shell invasions. Article 1, Section 8, Clause 16, Congress shall have the power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, direct relationship to the militia. Article 2, Section 2, Clause 1, President of the United States shall be Commander-in-Chief of the militia of the several states when called into the actual service of the United States. So we see there's a direct connection there between the amendment and the original Constitution. And when we go to the word militia, or the concept of the armed people, then we have to go, or we should go, back even before the Constitution, because the Constitution and the Second Amendment, they are not dictionaries. There's not some glossary attached to them that tells us what these terms actually mean. And these are terms of art. They're legal terms because they're found in a legal document, actually the highest of all legal documents in this country other than the Declaration of Independence. So we have to use that Maddox principle, that Supreme Court concept, that we have to look at the law at the time that it existed and really going back and seeing its development and evolution. And that's the same with the concept of troops, that's the same with the concept of Army and Navy. Historically, we have to analyze all of these provisions in that sense. So if we look at the original Constitution, we see something called the militia of the several states. Article 2, Section 2, Clause 1. The President is made Commander-in-Chief of the militia of the several states. Well, there they are. What are they? Clearly, they are part of the Constitution that cannot be removed because the Constitution makes them permanent, at least in the sense that the President of the United States is a Commander-in-Chief. It also makes them permanent in the sense of the powers of Congress to provide for calling forth the militia, to provide for arming the militia in Article 1, Section 8, Clauses 15 and 16. So we know right there we're dealing with a concept which isn't exactly defined, but we know that it has a relationship to the powers of Congress, the power of the President, and the right of the people themselves. Well, in looking at this amendment now, we have to consider all 27 words. And that's true also of the Constitution. And it has to be, as the principles I laid out earlier, it has to be construed in an integrated fashion. And this is really the fallacy of the Heller opinion, that the Heller opinion focuses on the last 14 words of the Constitution and treats them as the so-called operative clause. And the first 13 words of the Second Amendment, it treats as what it calls a preparatory clause. What's the basic fallacy? This is one sentence, the Second Amendment. There's no preface and operation. The whole thing is operative. Operative means has a legal effect. The whole thing has a legal effect. No English sentence is written, certainly by the author, with the intent that part of it should be disregarded by the reader. The author's intent is supposed to be gleaned by the reader from all of the words put together in the rational sense presented by the author. So that's one of the problems with the Heller case and the cases following on Heller. Now let's look at the first 13 words because they constitute what's called an absolute phrase. And people who have studied Latin know what absolute phrases are. If you ever read Caesar's Gallic Wars, Caesar loves to use them because they're a very succinct way of expressing a bigger point. And typically an absolute phrase is a phrase that states the most important element of the sentence. It usually tells us why. Alright? So, as an example from Caesar, you might have something in his Gallic Wars. Caesar, having led his legions into Gaul, the Allobroges fled across the Rhine. What's the important part of that sentence? Not the Allobroges fleeing across the Rhine. They probably did that many other times. The important reason, part of the sentence, the reason why they fled, was because Caesar led his legions into Gaul. Caesar is trying to make a point about his importance and the effect of what he did on this tribe. And that's the same in the Second Amendment. Those first 13 words, a well-regulated militia being necessary for the security of a free state. What's the important point there? What's the goal? It's the free state. And the 13 words tell us that what is necessary to the security of the free state is this thing called a well-regulated militia. Therefore, and that's how these absolute clauses can often be read, it could state a well-regulated militia being necessary to the security of the free state. Therefore, the right of the people to keep and bear arms shall not be infringed. And in fact, that's the way Article 1, Section 13 of the Virginia Constitution, which deals with the right of the people to bear arms, actually reads. It's a therefore clause. Right? So the important part is the free state. The operational method for achieving this, which is necessary, is the well-regulated militia. And a well-regulated militia can be maintained if the right of the people to keep and bear arms shall not be infringed. All right? The well-regulated militia is necessary, the only thing the Constitution so declares to be necessary. The people have arms for this purpose. It's interesting that the Second Amendment talks in terms of the right, not a right or some right, the right. Something that the founders and all the other people reading this document would have recognized as existing at that time, and in fact as existing, as having existed for decades before. It also talks about the right of the people, and that term, the people, is, well, it obviously comes out of the preamble, but it also appears in the First Amendment, the Fourth Amendment, the Ninth Amendment, the Tenth Amendment. So we pretty much know who's being referred to there. Then we come to the term arms. Well, simply within the Second Amendment, we say arms must have some relationship to the people's involvement in a well-regulated militia. That's pretty obvious on the face of that sentence. Simply the sentence tells us that. But if we go back and remember the Second Amendment is there to prevent misconstruction or abuse of the original Constitution, we start looking at the provisions of the original Constitution that might relate to arms. We find Article 1, Section 8, Clause 15. Congress will provide for arming the militia in order, it's Clause 16, in order to do what? In Clause 15, to call forth the militia to execute the laws of the Union, suppress insurrections, repel invasions. All right, so Congress is supposed to arm or provide for arming the militia for those purposes. Well, what kind of arms would be used for those purposes? Execute the laws of the Union. Those are police functions, we would call it today. And you think of what kind of arms your typical police, including SWAT teams, for instance, have on a regular basis. Pistols, rifles, shotguns, sniper rifles, some cases machine pistols, right? Automatic weapons of one kind, even automatic rifle. Typical, at least large city police forces. Suppress insurrections. Well, an insurrection could be some minor event, local riot. It could also rise to the level of something approaching civil war. You think of the so-called Civil War in the United States in the 1860s, and it was obviously warfare by any definition of warfare. But the official interpretation of that event was that it was a rebellion, as opposed to a true civil war. It was a rebellion because secession was claimed to be not constitutional, to be illegal. Well, all right, so you could run the full gamut of weaponry under those circumstances, insurrectionary circumstances. And of course, if you come to repel invasions, an invading army is going to be armed with certain types of weapons, and in order to repel such an invasion, the militia, or the regular army for that matter, would need to have equivalent arms, or arms of similar effectiveness. And in fact, when you look at this, one place where the Supreme Court has really attempted to integrate this whole question, the case of the United States versus Miller, way back in 1939, the Supreme Court in that case actually came up with what we would call a test, or what they like to call a test, to what the Second Amendment applies. And it was a tripartite test they came up with. It said that any firearm protected by the Second Amendment has to fall within one of these three categories. The first one is, has some reasonable relationship to the preservation or efficiency of a well-regulated militia. Now, we've already seen under the Constitution what a militia might have to do. Then the second test is it part of the ordinary military equipment? Well, that would include the regular army, because the militia might very well perform functions equivalent to the regular army, repelling invasions, for instance. Or the third part of the test is this weapon could contribute to the common defense. Well, the common defense runs from police functions all the way up to repelling of invasions. So we see that, at least in the Miller case, and reflecting what the Constitution actually says, this concept of arms is extraordinarily broad, or should be taken to be extraordinarily broad. An interesting kind of a sidelight on the Second Amendment is this concept of a free state. And if today we look at a free state, we say, well, what's the opposite of a free state? We'd probably say, well, it's a police state, it's a totalitarian state, it's a Marxist-Leninist state, whatever. We have modern day pejorative adjectives to apply. But in the time of the founders, they tended to categorize a free state in contrast to a slave state. You see this all through the literature. The British Parliament is attempting to impose slavery on the people in one way or another. And certainly the framers understood the difference because they actually had slavery in those days, right? And there were certain elements of slavery, the principles of slavery, which were called the badges and incidents of slavery. The slave was the property of the master. The slave didn't own any property of his own. The slave could be disciplined by the master, so on and so forth. Well, the primary, the absolutely necessary badge and incident of slavery was that the slaves were always disarmed. You can't have a slave society where the slaves are armed. So there's a distinction right there. One would say that even if the Second Amendment didn't exist, the 13th Amendment would have provided the same result, because the 13th Amendment abolished slavery and all of its badges and incidents. And that would have abolished as well disarmament of all free people, and that would have been all people, because there are no slaves anymore under the 13th Amendment. So what we see, I think, in terms of this dichotomy that's often created between the individual right and the collective right, it's really a fallacy. Because what? In a militia, the individuals hold their arms individually, not collectively. Unless we're talking about crew-served weapons, right? Artillery or whatever that might be used in a militia. There's an individual duty to participate in the militia, and there is individual ownership or possession or both of individual arms. Now, this dichotomy arises because in the Heller case, they tried to make out that the important point was self-defense. That the so-called core value of the Second Amendment was to allow people to be armed in case of confrontation. That's the actual phrase used to tell in case of confrontation. Well, I would just say that on the face of it, that's nonsense. That's not the core value of the Second Amendment. You read the Second Amendment, it doesn't say anything about that. Self-defense, interestingly enough, is actually a militia authority. Execute the laws of the Union, or in the states, execute the laws of the states. Why? Because self-defense involves execution of the law against the attacker. This goes all the way to William Blackstone commentaries on the laws of England, which was the most used legal textbook at the time of the Constitution and even before, where he points out exactly that. That self-defense arises in a situation where there is no other law enforcement authority available. The individual is executing the primary law of nature. And I might just quote that because it's a very interesting terminology he uses when he says that self-defense is justly called the primary law of nature, so it is not, neither can it be in fact taken away by the law of society. So we look at the Second Amendment, the well-regulated militia being necessary to the security of a free state. It of course would involve and protect and guarantee the so-called individual right of self-defense, because you can't have a free state without that primary law of nature being recognized and enforced. So there really is no difference between these two concepts. The individual and the collective right actually merge. Well, what is a well-regulated militia then? And we have people running around the country saying, well, that's private groups, they get together and they set up their own form of regulation, and they say what kind of equipment they're going to have and what sort of training they're going to do, but they are not the product of any state statute or regulation or congressional statute or regulation. And that's simply untrue. If you look at the history not only the words of the Constitution, which refute that on its face, but if you look at the history of these concepts which came in the Constitution we call the militia of the several states, these things existed before the Constitution was perhaps even thought of. They existed in all of the independent states, and they existed in all of the colonies except for one, Pennsylvania, and I'm going to get to that. There were colonial and state statutes, and every one of them provided for some kind of governmental creation and regulation and supervision of the militia. They're all the product of some statute. Now, in Pennsylvania, and you can find this, in fact, if you go to your Pennsylvania statutes, volume 5, on page 197, you'll find the actual statute I'm going to talk about. And then if you go to page 532, you'll find how the king dealt with this statute, which I'm also going to recite to you. Pennsylvania had a peculiarity in that it was founded by the Quakers. And as you know, the Quakers are pacifists. They don't believe in the use of arms. And at this time, we're talking about the middle 1750, 1755 or so, 1756. The Quakers were dominant economically, socially, culturally in Pennsylvania, and politically, and in the legislature as well. And they felt that it was improper for them, given that they would not bear arms, to require as a matter of law that other people had to bear arms. So there had not been a typical militia statute in Pennsylvania. Benjamin Franklin comes along and says, wait a minute, this is a problem because at least in the western part of our colony, we really need to have people organized under arms, deal with the Indians, typically. What are we going to do about it if the legislature will not pass a compulsory? So, well, we'll create a voluntary statute. We'll set up a statute that has various provisions in it, and people can choose voluntarily to take advantage of these provisions and form essentially volunteer militia companies, as opposed to the compulsory militia companies that existed everywhere else. Well, this statute had to be sent to the king, or his privy council, basically, for approval. All colonial statutes did. So it went to the king, and as I said, you can find this in the appendix to volume 5 of the Pennsylvania statutes. The king disapproved it. Why? Well, because the king was the commander-in-chief of the militia everywhere, ultimately the commander-in-chief. Because all of these colonies were British possessions, right? And the essence of the British militia and the militia of all the other colonies was compulsory membership, subject ultimately to the king's command, and he would not countenance a statute that had voluntary participation with people who were, in some large sense, the way that statute reads, perhaps not subject to the king's command. Now later, when Pennsylvania becomes a state, Declaration of Independence era, then Pennsylvania passes what I would call a legitimate militia statute, one that followed the actual legal principles that have been applicable since the middle 1600s, let's say. And it probably has that today, at least in some kind of basic form. Now, the reason that some people talk about voluntary militia is they say, well, you can form independent companies. Independent companies were sometimes formed in the colonial period or in the Revolutionary War period. And that's, again, a mistake. You have to look at the history. Rhode Island had lots of independent companies, for example, and what these were, a group of people came together, usually people who were fairly well off, they were fairly wealthy, and they petitioned the legislature to grant them a charter saying that they would form a company. They gave themselves some fanciful name. Kingston Reds is a good example. Nathaniel Greene was a member of that independent company. And that they would have so many members of their independent company, and they would arm themselves and train and equip themselves and so forth and so on, pursuant to the requirements of the actual militia statute of Rhode Island. And they might say they would do even more. instead of having to come out 4 times a year, they might come out 6 times a year, 8 times a year, whatever it was. So they wanted to be treated as kind of an elite member of the Rhode Island militia. And sometimes they would ask in their charter that when there were battalion musters or regimental musters, that they would take some place of honor in the the trooping of the militia. And then this would go to the legislature, and the legislature would approve it. And then this group would become an independent company under whatever fanciful name they had. But they were part of the militia. They were not a separate independent organization. In Virginia, an example arose, 1773, the militia statute ran out. It was sunset. They were already having problems with the royal governor. And the royal governor was preventing the legislature from meeting to pass a new militia statute. And in fact, he was threatening to arrest Patrick Henry and some of the other patriots. He called on the militia to help him do that. The militia refused to do it. I don't know how he thought he was calling on the militia when the statute had expired. But in any event, there was this confusion. He eventually absconds with a stolen printing press. He gets out a British man-of-war in Chesapeake Bay, and he churns out various proclamations which no one followed. Eventually, he retreats and he goes off to New York. And during this period when they didn't have a statute, in some places, Fairfax County being the one that's always cited, they formed independent companies because there was nothing else that they could do. And I would call that extra-legal, because there wasn't a statute that they were actually violating, so it wasn't completely illegal. The governor would have called it illegal because he wasn't the commander-in-chief. And as soon as they declared independence in Virginia, they passed a formal ordinance to recreate their militia on the traditional compulsory lines, not as a private organization. Now, another example of this, you can see in the Articles of Confederation. The Articles of Confederation call on the states to always maintain a militia, not on private parties. Then there's a resolution of Congress in 1775, essentially says the same thing, lays out some principles. So there's no question, the well-regulated militia that we're talking about in the Constitution, Second Amendment, has nothing to do with private groups. Now let's look at the Second Amendment in terms of its relationships with states. All of the Bill of Rights, other than the First Amendment, if it's correctly interpreted, all of them apply to the states from the beginning. Of course, we had the Supreme Court making a grotesque error very early on, a case called Barron versus Mayor and Council of Baltimore, saying that no, the amendments didn't apply in any way to the states. Well, that's obviously not true. The 9th and 10th Amendments just read them. And the reason the Second Amendment obviously applies to the states is because we're talking in the original Constitution about what? The militia of the several states. That's the group of governmental entities to which the Second Amendment refers. Right? So the Supreme Court's concept there, going way back, is completely erroneous. And actually, if you look, there's a book people should read if they're really interested in getting into this detail. William Crosskey, Crosskey, Politics and the Constitution, Volume 2, has a couple of chapters dealing specifically with this particular point. But in any event, the Supreme Court subsequently has applied the Second Amendment to the states through the 14th Amendment. That's what the McDonald case did. That's what the Bruin case did. Heller involved the District of Columbia, so it's somewhat different. But the bottom line is the Second Amendment applies to the states now as it should apply from the very beginning. So now we go to the constitutional principles of the militia. What are these things? Well, they're state institutions. And they're supposed to be armed and organized and disciplined and have some form of governance. And at the national level, they can be called for by Congress under the authority of the President as Commander-in-Chief to execute the laws of the Union, suppress insurrections, repel invasions. Execute the laws of the Union, notice that. Not the laws of the states, but the laws of the Union. So they form a kind of national police force if they were properly used correctly. If they're properly used. We wouldn't need a Federal Bureau of Investigation or many of these police functions that occur in the other administrative agencies. Supposedly, according to the Constitution, that's supposed to be done by the militia in several states. you have certain segments or parts of the militia, the Constitution refers to them, Article 1, Section 8, Clause 16, parts of the militia called into the employment of the United States to perform those functions. And that would be a much better situation because now you'd have direct, in the true sense, federal involvement. The states and the people would be directly involved, not having some aloof federal bureaucracy, the so-called deep state that we talk about so often today. And another principle of the militia is, well, everyone's supposed to be armed. Well, who's everyone? If you look at the history of this, it was people from 15 to 16 years of age up to the late 40s, 50s, maybe 60 years of age. Why 15 to 16? Well, because that's the point at which, certainly in the founding era, people expected an individual to be physically and intellectually and emotionally and morally capable of bearing arms, assuming that important responsibility. When you got up to the late 40s, 50s, 60 years of age, you were talking about people who were suffering from chronic ailments, incurable ailments, heart disease, tuberculosis. You think of that as one that was pretty rampant. They might have had liver disease, gallstones, kidney problems. Some people may have had problems with vision that couldn't be corrected by the primitive forms of eyeglasses they had in those days. It might have been crippled, perhaps from birth, perhaps from some disease, perhaps from having broken bones that weren't set properly. These people could not function. You might have had even what we call today Alzheimer's, forms of dementia, right, at that age. Most people did not live to be 50, 55, or 60 years of age. So it was improper, unjust really, to require that people at that level of, as it were, physical decomposition would have to serve in organizations that were to a large extent paramilitary. And that's why they had those age limitations. Well, oftentimes it didn't apply because if you were someone in the elite, you might be a high-level officer in the militia and you might still be 55, 60 years of age. And certainly you weren't prevented from performing that function. No one was prevented really if they were capable of performing that function if they volunteered. So if you look at the statute in Virginia, I don't know the statute in Pennsylvania directly. Statute in Virginia, everyone's a member of the militia from 16 years of age to 55. And you can be called out, you're not in the National Guard, or what they call the Virginia Defense Force, which we'll get to. You can be called out to execute the laws of the Union, suppress insurrection, repel invasions, deal with natural disasters. There are a couple of other things in Virginia that the militia are competent to deal with. And if you don't respond to the governor's call, you can be court-martialed. It's right there in the statute. People over 55, such as myself, we're not subject to those provisions, but there is a separate provision that allows the governor to call any of us out if he wants to. And then we become part of the so-called unorganized militia. So Virginia, at least in the basic principle, follows this historic pattern, which Congress followed, by the way, from 1792 onwards. We'll get to that in just a moment. But another principle of the militia was everyone was supposed to be armed. How armed? Well, armed with an arm that was conducive to performance of militia functions. And the statutes would describe that type of arm, all the way through the colonial period, all the way through the period of the independent states, and subsequently, Congress passed the statute in 1792, which continued through the revision of the statutory code in 1873, all the way up to 1903. All right, so we're looking at over 100 years, that particular statute, and it required that members of the militia, as defined by Congress, to be called out for national purposes, that had to have a good rifle. That was one of the requirements. What was a good rifle? That changed in terms of situation from the 1790s to 1903. It went from good rifle being a muzzle-loading flintlock to a percussion muzzle-loader to a cartridge rifle of some kind to what the modern bolt-action rifle, which was certainly available in 1903. So we had a real progression. The statute never changed because it said good rifle. A good rifle depended on what time you were living in. A rifle that was good for performing militia functions obviously changed from 1792 to 1902, 1903. All right, now that brings us the National Guard. National Guard being something different from the militia. The National Guard first appears in the Dick Act of 1903, named after Representative Dick from Ohio. The National Guard actually consists of troops, not militia. Good Article 1, Section 10, Clause 3. No state shall, without the consent of Congress, keep troops or ships of war in time of peace. And that refers to a tripartite structure that existed both during the British colonial period and War of Independence. British colonial period, there were three types of military forces. There was the regular British Army, there were the provincial troops of each colony, as the British called them, and then there were the militia of each colony. And they were separate and basically independent. The provincial troops were actual state troops, and the militia were something else again. Provincial troops in the British Army were essentially volunteer organizations. Congress comes along in the War of Independence, and you had, again, three bodies of troops, of military forces. You had the Continental Army, under the direct control of Congress. You had the state troops, usually called the state line, the Virginia line, the Maryland line, whatever. And they could come under the command of Congress and be adjuncts to the Continental Army, or they might maintain themselves separately within their own states, or actually go from one state to another in the course of the war. And then you had the militia, and they tended to be localized, moving militia forces typically from one state to another. They were localized. Actually, both sides had militia. The Tory militia and the Loyalist militia on the side of the British, and the Patriot militia. And this comes out most clearly in terms of what was going on in New Jersey. And when we read the history of New Jersey during the War of Independence, we'll see this conflict, guerrilla warfare really going on between the Loyalist militia, the King's militia, and the Patriot militia. So the National Guard actually consists of troops, and we know that from the history. The National Guard concept arose out of the militia because lots of people from very early on didn't want to have to put up with the burden of militia service. Joseph Story, Supreme Court Justice, writes in his commentaries on the Constitution in 1830 about exactly this problem, the kind of contempt in which the militia were held by people who didn't want to participate. And he said this was a great danger. But there were some people in the militia who did want to participate. The people who, in a sense, wanted to play soldier, or they wanted to play true militiamen. And they were willing to go out and extend effort and money to do this. Well, in I think it was 33 or 32, the Marquis de Lafayette, remember him, he was served under Washington in the Revolutionary War, came in with the French forces. He comes on his last visit to the United States, and he lands in New York. And New York changed the name of its militia from, I guess, New York State Militia to the New York National Guard in honor of Lafayette, because Lafayette had been the commander of the National Guard in France during the Revolution. Now, there's kind of a checkered history of that, because what the National Guard became and what it did, and then it eventually becomes the imperial forces under Napoleon, etc. Right, we can go on into that. But at this particular time, they were looking to Lafayette's participation way back then, and in honor of him, they changed their name. And this concept was picked up by a number of state militia. They started calling themselves the National Guard. And it really referred to that part of the militia where people were essentially volunteering to do more than the statutes really required, or they were volunteering to do what the statutes allowed them to do as volunteers. So you had a dichotomy in the militia between the compelled service, which never changed under Congress. Under Congress, it was always compelled. And this volunteer service by people who tended to put in their own money, their own time, they provided their own uniforms, so it was very much like the independent company concept in Rhode Island. And the National Guard people wanted very much to be considered the equivalent of the regular army and to be respected as such. So they kept coming to Congress to get funding and to get training and eventually to get statutes passed which provided that they would receive the same arms as the regular army. Well, you have a problem here because they were not really militia in the sense of the understanding of constitutional understanding of militia. And the Dick Act solves this problem by creating the National Guard as a separate entity. They called it the organized militia, which I call bait and switch language. And they put everyone else into something called the reserve militia, and then a few years later term was changed to the unorganized militia, which of course is a false concept because there can never be an unorganized militia. Look, historically, there was never such a thing. And it can't be under Constitution otherwise because Congress is empowered to do what? Provide for organizing, arming, and the very first word is organizing. So we look at that whole structure, and it's basically nonsense. But there's a speech that was given after the Dick Act was passed. National Guard Association of the United States, a big lobbying group. They have a congratulatory meeting, and one of the speakers was Elihu Root, who I would call an insider's insider, a very high-level political figure. And he gives a speech, and he says very specifically in that speech, well, thank goodness now we passed the statute, because now, finally, for the first time, the National Guard has a constitutional basis. He recognized the National Guard of these things called troops. And Congress's consent, which is necessary to have state troops in times of peace, has with it all sorts of requirements. And one of the requirements is the National Guard will function as an adjunct of the regular Army or the regular Air Force, which have the Air National Guard now. So the National Guard really forms this third function. The militia on the one side, the regular Army on the other side, the National Guard in the middle, the state troops which can be used by the regular Army. That's why you find the National Guard fighting in Europe in the First World War, fighting in Europe in the Second World War, fighting in the Pacific during the Second World War. Obviously, militia can't be called up for these foreign entanglements. But the National Guard could be because it was and is an adjunct of the regular Army. And you see this example of the tripartite structure. Virginia statute, militia of Virginia, is divided into three parts. The National Guard, the Virginia Defense Force, and the so-called unorganized militia, which is everybody else. Now, the Virginia Defense Force is a peculiarity. It comes up under Title 32 of the United States Code, Section 109. It's the other troops. If you look at the statute, it even talks about this. It says the other troops that a state can raise, because the original troops are the National Guard. And if you look in Virginia, the National Guard, Air and Army National Guard amount to 9,000-something people right now. And the Virginia Defense Force is adjunct of the National Guard. It has by the statute it can have up to 1,200. Probably now it has 200 to 300 people. So we might have 10,000 people in those two troop units, National Guard and Virginia Defense Force. There are over 4 million people eligible for the unorganized militia of Virginia. And even more than that, if you include the old people such as myself, who could be called up through the special provisions that the governor has. Well, those 4 million people are completely unorganized. If they're armed, it's only adventitiously because they've armed themselves. They went into the free market and bought guns at some gun store. And they certainly are not being trained as members of the militia. Now, they could be, because the governor has some fairly broad general powers to do those things, to allow people to use their own arms, to arm them if they don't have their own arms, to train them. But he doesn't do anything. There's no provision. So what we see is that the actual militia, the constitutional militia of this country, are basically moribund. That's problem number one, the major problem. because one is guaranteeing the freedom, the